Hi, welcome to today's webinar. I'm Jeff Hurd. I'm a member of the State Bar of South Dakota CLE Committee, and I practice at the Bangs McCullen firm in Rapid City. Before we get started, I'd just like to go over a few items so you know how to participate in today's event. First, if you know of a lawyer or a law student who has a drug or alcohol problem or are struggling with depression or anxiety, Lawyers Concern for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit to LCL is strictly confidential and privileged. Call Becky Porter for more information at 605-391-5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. Today's presentation will last approximately an hour, and you will have an opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send your questions at any time during the presentation, and we will collect these and address them during the question and answer session at the end of today's presentation. Now I'd like to introduce our presenters. Heath Oberlo provides business and estate planning advice for a wide range of clients, with a particular focus on succession issues for family-owned businesses and farms. He also works with families seeking to take advantage of South Dakota's favorable trust laws to establish trusts in or move trusts to South Dakota. Heath is a board member of the Sioux Falls Estate Planning Council and a member of the Business Law Committee of the South Dakota State Bar. Jordan Burink assists clients in all aspects of business, estate, and tax planning, including drafting trusts, wills, and business succession documents to implement the plans. Jordan also assists clients from around the world looking to take advantage of South Dakota's favorable trust laws. Jordan is a vice chair of the ABA Real Property Trust and Estate Asset Protection Committee and a member of the Business Law Committee of the South Dakota State Bar. Chad Hansen has worked in the real estate and title industry for over 20 years. He has worked to help title agents and clients find creative solutions to title and real estate problems in both residential and commercial transactions across the country. Chad is a member of the Business Law Committee of the South Dakota State Bar and the American Land Title Association Forums Committee and Native American Lands Work Group. And with that, here is Heath Oberlo to start us off.
All right, hello everybody. This is Heath Oberlo. Happy to be able to present to you today about Series LLCs. And just by way of background, Jordan and Chad were part of the subcommittee that we worked on drafting the legislation for the Series LLCs. So first you'll hear from me about some of the history and just general information about the Series LLC. Then I'll turn it over to Jordan, who will provide some information about series with respect to how they might be used in the trust context, and then Chad will provide us a little bit of real estate context. So I want to thank both of them for volunteering to help me out with this. So all right, so just introduction. So what is a Series LLC? And I think the best way to think of a Series LLC is like a coax cable, where essentially we're allowed to create multiple series of LLCs or mini LLCs and wrap them up into one LLC. So the benefit of that, or the main reason for doing so, is we can provide for limited liability protection amongst each of the series. So the liabilities of one series cannot be enforced against the assets of another series. One of the other interesting concepts or constructs that you can use with a series is you can have different members of each series, you can have different managers, you can have different ownership percentages, and it's all wrapped up legally within one LLC. So the idea behind the LLC initially is, the idea behind the Series LLC is to provide that kind of parent subsidiary structure, but make it more simplistic and efficient. So basically, instead of having one parent LLC with multiple subsidiaries, you can create one series LLC that just then has multiple series within it. So it's a little more easier, efficient way to kind of segregate some of the valuable assets of the business from what could be the liabilities of the business. So as with many corporate ideas, the Series LLC initially was created in Delaware, started quite a few years ago already. They used it in the mutual fund industry. It was primarily as a way to allow the LLC to apply for one registration with the SEC, but then have multiple funds underneath it that may have different investment strategies, different money managers. So it's been used in Delaware since then, and probably over the last 5 to 10 years has gained a little more steam with respect to other being adopted in other states as well. So our probably 5-6 years ago, there was a subcommittee established for the Business Law Committee to look at whether South Dakota should adopt the Series LLC legislation. So we've been working on it since then. We were able to get the legislation drafted, approved by the state or by the Business Law Committee, and then the state bar at our annual meeting in 2019. Submitted it up to the legislature during the 2020 session where it was passed. It's a little unique for this legislation versus typical legislation where this did not go into effect until November 15 of this year. A lot of that was due to just some of the additional programming time that it would take for this Secretary of State to kind of update their software system. So we were worked closely with the Secretary of State's office putting this legislation together, and they were made it easy for us. So I haven't done a formal in-depth review lately, but we're probably up to about half of the states that now currently have some form of Series LLC legislation. So with respect to how states are adopting the Series LLC statutes, there is a lot of variation between the states on how they're doing it. Some states have taken the approach like South Dakota, where there's some formal legislation that's very clear on what Series does. Other states like our neighbors Minnesota and North Dakota have just referenced that there could be a series formed, but there's really no specifics in the statute on how a series is treated vis-a-vis the liabilities of other series or of the LLC. So it is something as these become, or as you use these with clients, to just be aware of where the business of the Series LLC may be conducted, just to make sure that the protection is maintained. So initially when these were created or set up under Delaware law, there's really no public filing that was made for the series. The articles were filed, or series were created through the operating agreement of the LLC. So there's really no way for John Public to know if an LLC had a series or not, or even whether you were doing business with a series. And so I think that was probably one of the reasons why they were not adopted very quickly, because I think there are a lot of people who are just a little nervous from that standpoint of providing notice to the public. So I think Illinois was probably the first state that adopted a structure where you could create series, but there was a public filing required for each series. So the structure is you file articles of organization with the state, and you include a notice in those articles that the LLC may create series. And then each time a series is created, you file some additional filing with the Secretary of State so that people can see what series have been created. So that structure gained a lot more traction amongst other states. So it's been adopted by quite a few of the states that have now adopted the legislation, and our statutes follow that approach as well. So our statutes are currently found in the LLC statutes there in Chapter 34A. As I mentioned, we follow the approach where articles of organization are filed with the state. And there's a box now on the standard form, or there's some reference, or you need to include some reference that this LLC can create one or more series. So just as an example, I went ahead and filed articles of organization, and in the spirit of Christmas coming up, called it the Griswold Family LLC. That should be attached as one of the handouts to the presentation. So you can also, if you have an existing LLC that you want to create series under, you can file articles of organization or amend it, or you can amend your articles of organization to allow for the creation of series. So then each time a series is created, you need to file what's called a certificate of designation, and that gets filed with the Secretary of State. So the name of the series has to contain the name of the LLC, and the Secretary of State's kind of specific on the order that they want to be used. So again, I filed a certificate of designation for a Clark series and a Eddy series. So I plan to have a Christmas tree farm operated under my Clark series, and probably a sanitation service operated under my Eddy series. And you can see it does have to, or the name does have to incorporate the entire name of the LLC. The Secretary of State also wants the name of the series to be before the LLC. So some states you might see a structure where it says, Griswold Family LLC dash Clark series, but that won't be the way it is in South Dakota. We'll include the name of the series before the LLC. So the important part about this series LLCs is we do have limited liability between each of the series. So Section 702 provides some of the conditions that have to be satisfied in order to obtain that liability protection. As I noted, the first important thing is you have to include a notice in the articles that you will be creating series. You also have to reference it in your operating agreement and then provide for how those series are going to be operated. One of these following two things are important, and you have to maintain separate and distinct records for each series. So that basically means you want to create a separate depreciation table or balance sheet, have some kind of way to keep records of what assets are held by each series. And then you have to separately account for each of those assets as well. And I think it's important to note you don't have to title assets in the name of the series. You do have the ability to do so, or you should. And some from a lending and real estate standpoint, you may have to, but the statutes do not require it. And then one of the other important things that our statutes do is they identify or clarify that each series is a separate legal entity. So that's important because then each series has the ability to enter into contracts on its own. It can hold titles, it can give security interests, and it can sue and be sued just like a normal LLC does. That's important for many of those reasons referenced there from a financing standpoint, from how you transact real estate. All those things are, I think will be important that assets do get titled in the name of the series, and that each series can transact business on its own. So most of the guts of how your series are going to operate with respect to your LLC is all going to be governed by the operating agreement. So that will certainly take some time to refine the language that we currently use for our normal LLCs to try to figure out how the operating agreement for a series might look. Like I said, it can be as simple as everything's the same, other than we're having multiple series, so the same managers, same members, same ownership percentages, profit distributions, voting rights, can all be the same. Conversely, all those things can be different amongst each series. So it's really going to be however creative you want to get with the structure of that operating agreement. Foreign series, series set up in a state like Texas or Missouri can get authorized to transact business in South Dakota. And you can also make changes to each series by filing either a new certificate of designation or an amendment. So if you want to change the name, change the managers, change how it's managed, any of those things will be done by filing a new certificate of designation. And then you can also terminate a series separate from the LLC. If you terminate the master or the main LLC, that will automatically dissolve all the series underneath it. So you need to obviously pay attention to that. So we got some of the filing fees here. So you'll note the filing fee for the articles of organization is $50 higher than what a typical fee is. Same thing for filing an amendment to allow your current LLC to authorize series. So that's one way or one concern I think from the state standpoint was if everybody starts creating a series LLC instead of multiple LLCs, that will potentially decrease the revenue payable to the Secretary of State. So that's why there's a little bit increased cost for the creation of a series LLC. Each certificate of designation will be $50. You'll only file an annual report for the master LLC, so you don't have to file an annual report for each series. If you have an out-of-state LLC that's authorized to issue series, then the filing fee is again $50 more than the typical one. Included the link there for the forms, so you can go to the Secretary of State's website and see what those look like. It doesn't look like, at least at this point, that you can use the online filing system for series, but I would assume that will occur at some point in the near future. All right, so that's a lot of the background. So now probably the big question is, what's the point? Why are we doing all this? And I think really as I mentioned before, the main reason or the main instance where you would create a series LLC is in those structures where you might typically use a parent subsidiary model or even the multiple affiliated entity model. So this is where a series LLC might come into play. You should be able to reduce your filing fees from the standpoint of the initial $150 fee, as well as your annual filing costs. So there should be some of those cost savings for clients. Depending on how you're reporting for your the income taxes, or how your clients are reporting for income taxes from a holding company or disregarded entity standpoint, the series may provide you a little bit of savings there. In theory, if all the series have the same ownership, it should just only require one tax return for the series LLC, and should not be required to have tax returns for each individual series. And then in theory, clients should have to pay less because you're not creating 10 LLCs, you're only creating one LLC. In theory, there should be less legal work. Depending on how complex the operating agreement is, though, that may counterbalance some of those cost savings, particularly if you want different ownership percentages and management provisions within the series. So as when LLCs were first introduced in Wyoming back in the 70s, like that, series LLCs are still relatively untested. There hasn't been a lot of court cases that have addressed how detailed the accounting records need to be between a series, or how piercing the corporate veil type theories would be or would affect a series LLC. And there's certainly states that have not authorized series LLCs. So I think there's certainly some risk in kind of the unknown of, will the intra-series liability be respected, and particularly if you're operating in a state outside of a state that authorizes these. I think there'll probably be some challenges from the standpoint of financing and contracting with third parties. It'll be it's a new animal for them to deal with. From a financing standpoint, they'll need to understand how and where UCC filings are made, how mortgages are recorded, title work behind some of those things. So I would expect for the first number of years that there'll be some learning that everyone will have to do if you're using a Series LLC. Another area that's a little unclear at this point is can a series file for bankruptcy on its own, separate from the master LLC? So that's going to depend. Again, that's not real clear. But it's going to depend on how courts will interpret the definition of person under the bankruptcy code. Traditionally, LLCs have been allowed to file bankruptcy on their own, separate from the members, for example. Usually, the analysis the court goes through is whether the quote-unquote person filing is an entity, and so because our statutes do specifically say that each series is an LLC, that should address this issue. But again, it's certainly an open question. So another area, and I touched on it a little bit, is how series LLCs will be taxed, or specifically how each series will be taxed. Presumably, or at least the IRS has indicated that if each series qualifies as a disregarded entity, then those disregarded entity rules will apply for that. So that should minimize the need for multiple tax filings. But otherwise, they do say, as with the bankruptcy code, if the series is a separate entity under state law, then the IRS will presumably tax it as a separate entity. There's some states that, or I think for sure Texas was one state that maybe was going to follow a different route, but typically the states have indicated that they'll follow the IRS rules on how a series is going to be taxed. One note I didn't include in the slide, but if you have a series LLC that will be doing business in California, expect to pay the $800 a year franchise tax on each series that's doing business there. So just for the privilege of doing business there. I think the biggest issue for South Dakota series LLCs will probably be the sales tax rules, and if there's transactions between series, just to make sure that either you qualify for the common ownership rules that the state has for sales tax, or be ready to or make sure that you're charging sales tax if there's services between series that don't meet that common ownership requirements. I do think each series would or should have its own separate sales tax ID number and should report those returns separately, at least for now. All right, so some of the places where, I guess we want to talk a little bit about, how do you use these? Why would you use them? What are some examples of where you might use them? So we've laid out a few examples here. I think for the most part, it'll be up to the creativity of the attorneys on the call and other attorneys around the country that are using these entities and just coming up with new and creative ways to use them. So, I think some of the more common places where we would see these being used would be for residential real estate. So if you have mom and pop client that have 10 rental properties in town that they rent out, instead of having 10 LLCs that you might form, you can now create one series LLC and put each house into one series. Same thing for multifamily type housing. Each building could go into a separate series, and that provides the protection of the liability if something goes wrong at one facility. It doesn't impact the rest of the value of the other properties. Same thing can be used for commercial real estate holdings. So you can put each office building into one series, or if you've got office buildings in one series and industrial buildings in another series, you can kind of segregate those uses and segregate the different risks that go along with those types of properties. Theoretically, or I guess one other area is you could use it in the logistics area. So if you have a company that's involved in trucking, they might have 50 different trucks. I have a client in this line of business, and they've told me what their insurance premiums have gone up over the last several years. And so this might be an option for higher deductible type plans where you can just know that try to limit the liability. So each truck could be a separate series. Each trailer could be a separate series. And then if something goes wrong on the road with one of those trucks, that should prevent a mass liability issue for the entire operation. I think another option or another area would be in the construction area. It seems like a lot of construction people aren't just doing construction, but they're also doing property management. They're doing design build. So there's a lot of different pieces of their business. And so a Series LLC would be an option for them to operate each division under a separate series. And so you might have, if you're installing utility lines on one day, and then you have on one crew, and the other crew is just wiring a multifamily property. You could separate each of those operations and the equipment that goes along with them into a separate series rather than creating a new LLC. So another area which I'm kind of excited to try these out for would be in agriculture area where, from a estate planning standpoint, a lot of times it's difficult to get farmers to change up their operation too much. Kind of like the simplicity of sole proprietorships. But if we can create one LLC that holds, one series holds the equipment, one series could hold the land, one could hold the operating entity, one could hold all the pickups, or excuse me, the semi trucks that are hauling grain back and forth to the field during harvest. You can have separate series for all those, which should make life a little easier from an operational standpoint. But then what that also allows us to potentially do is allocate those series to different kids through the estate plan. So for example, the real estate Series LLC could have the non-farm kids as owners, or percentage owners, and then the operations and equipment, those could be given to the kids that are working the farm or working in the operation. So those are certainly tools that we can use now. It just requires multiple entities and just more bookwork and headaches for the clients, which can tend to slow down the adoption of some of these plans. So I think this would be a good option for the farming, particularly in the estate planning area. And I touched on the real estate development. I kind of repeated myself there. So, but I think the main story is anytime there's different liabilities, anytime there's different operations or assets where you want to lease assets from an operating and or have an equipment holding company and lease those by the operating company. IP holding series could be an option as well. So all those are good options for using a Series LLC. All right, so I think this is where I'm going to turn it over to Jordan. Beth, if you want to.
All right, Heath, am I on the right screen? Can you see that okay?
Yep.
Perfect. Okay. So thanks for background, Heath. That's very helpful. I'm going to probably duplicate a few of your efforts here, but my first thought when we started to put these things together was in light of my trust-focused practice and estate planning practice, is how are we going to be able to use this to help clients that are looking at estate planning, trust administration? How can it be used to help those types of clients? So just as background, a lot of people that set up trusts here who are not from South Dakota but want to use our state as to get the benefits of South Dakota situs will name a trustee and then set up, typically they're going to set up a holding company, a traditional type of LLC oftentimes. Sometimes they'll hold assets, they will have the trust hold outright assets, but that's a little less common. But then, typically have this single holding company and then have that own other things, whether it's a business interest, whether it's accounts, any number of things. And so I give that as background because I think that's kind of why we're going forward with this Series LLC, why we wanted to put those into place and kind of advance that cause to begin with, because that's essentially what this does, but makes it a little bit easier and less expensive, and potentially can make things, provide the asset protection and the ease of administration and asset protection and lower expenses for the trusts. So as with that background in mind, as I kind of mentioned, the goal then was to, how do we use these Series LLCs in South Dakota? Much like the single member holding company that we use for these trusts, we can set those up, or could set those up as the master LLC, and have that master then own, any number of series, whether it's, there's probably a de minimis somewhere, whether it's 5 or we get 2, who knows, but it'll be up to the client and the attorney, but presumably up to as many as we'd like to have it own, depending on the different liability risks, different assets, things like that. I have in here that each series has separate characteristics from the parent or the series. I didn't quite word that correctly. It probably is better said could have characteristics that are different. Honestly, I think the sky's the limit. Oftentimes in trusts, I suspect it's all going to look the same. If you're going to have, you as a client are going to set up your trust in South Dakota and make it a series, odds are if you want to manage one entity, you're probably going to want to manage the others as well. But again, as Heath mentioned, the assets and the management, all those things can be the same or can be different depending on how that looks. So why are we, what are we doing this for in the trust world? And Heath mentioned the cost. It's going to save money as far as the additional designations for the series, despite the upfront cost being a little bit higher. Certainly, as this gets to more and more series, you're going to have more and more savings in that regard. And asset protection, I mentioned in here, we presumably had that anyway as far as the parent and sub. But because in South Dakota, you can get those protections with a series at a lower cost and provide some ease of the one LLC type wrapper, certainly if you're going to get similar type asset protection, that makes sense to use the series instead of, a parent and then a number of subs. And Heath mentioned this before as well, but something we'll want to always be sure of is that this, despite the asset protection this was going to give assets in South Dakota, with clients that are out of state, we'll want to make sure that the assets that are placed in these series LLCs or in the subs underneath the masters are in holding property in states that would allow the protections that South Dakota is going to offer. For example, if Minnesota doesn't allow series and you put Minnesota farmland in an entity or a Minnesota operating business, you may run the risk of not getting the protection you're seeking if there's a potential for litigation to happen in that state, and that would affect the series and what that might offer from the a planning standpoint. So the first thing I really had thought of, and I think the reason that in my perspective we needed to talk about this in South Dakota is people were asking about it, of course, but some trustees were a little concerned about holding series LLCs that were formed in other jurisdictions in South Dakota, and what does that mean for getting the protections of South Dakota law and having their trust cited here. So again, I give a little bit of background here, but basically records or assets or records of those assets need to be held in South Dakota, among other things, to ensure that South Dakota the trust has its situs in South Dakota. I think there's some gray area there in terms of what's enough. Can it hold a Delaware operating agreement here? Is that good enough or is it not? That's a better question for our trustees and what they're hearing from the Division of Banking, certainly. But if you have the option to hold a South Dakota asset, certainly that's going to make a better appearance and a better fact if you're having to ever argue the issue that South Dakota does govern the trusts and the trusts are sited in South Dakota. So I give a little bit of background here, and I, oddly enough, omitted probably the most important part of 55.339. So feel free to look at that section. What it goes on to say, in addition to the underlined piece there, that some or all the assets are deposited in the state or physical evidence such assets is held in South Dakota. But it goes on to say that would include assets deposited in the state, such as checking accounts, certificates of deposits, brokerage accounts, including South Dakota investments. And so when you go to that next bullet point there, 55.343 expressly states that any equity or debt securities of a corporation, partnership, or LLC organized in the laws of South Dakota is a South Dakota investment. So kind of a long way of saying that having a Series LLC that's formed in South Dakota is probably going to create a much better fact for any trustee that has any concern about the assets being located in South Dakota. So privacy, again, what governs regular LLCs as far as the disclosures have to be made isn't going to change significantly with respect to series. If it's member managed LLC, typically a series member managed LLC would give that same protection. A member name wouldn't have to be disclosed. If it's manager managed in a traditional LLC, the manager would have to be disclosed. And there is a box, if you look at Heath's materials, and I won't try to pull that up because I think I'd mess up the screen here, but if the management of a series is different, there is a box you have to check there and acknowledge who the manager is. So unless it's the same, just so they can always kind of tie that back to the original if necessary. So again, you want to set these up, and we encourage all trustees here to hold those assets in an asset protection wrapper of some kind, typically an LLC. And I think my point with this section was that a series is going to provide similar asset protection as far as the assets to what the parent and sub type relationship would hold. And that's a good thing in terms of what trustees are going to be used to. Okay, so operations and management, I mentioned this before a little bit. In terms of disclosures, of course, if a manager is listed, you are going to have to disclose the name of the manager with respect to the articles of organization of the original series LLC or traditional LLC. And then as far as the annual reports, the same disclosure would have to be made. And in the series, that would be on the master's annual report. We do often appoint presidents, and I pause to say there are probably going to be ways that we can not get around anything, but certainly there are going to be structures that we can try to arrange to provide, going back to privacy, some level of privacy about who's managing some of these things. And we'll want to, I think, as Heath mentioned also, I think we're going to have to kind of keep our eyes open for, when's the right situation to use this, and how can I go about structuring these in a way that does provide me the easiest operations, the best privacy, and things like that. So dividing assets, and this also goes back a little bit to traditional LLC type planning, but trustees, well, let's go back to estate planning first. I think it's always easy in the context of farming to say, well, I want the west 40 to go to child A, the east 40 to child B, and set that all up. And we've done that, the same way for years and years. I think in this way, it's a nice way to make this work from a series perspective, is having, as Heath mentioned, using certain types of assets in the farming context, but then being able to just designate certain series to go to certain kids. And because you can change how those are administered, and because we allow for different in terms of master and the different subs, you can allow for these different assets to keep their liability protection wrapper, and then have the LLC itself be eventually owned and or managed by the beneficiaries you choose. In terms of trust administration, we oftentimes when someone passes away or there's some other kind of triggering event in a trust, trustees have to divide these assets up into shares or subshares or distribute them outright to beneficiaries. And the same thing can apply there. The grantor or even the trustee with the consent of the beneficiaries or without that can go ahead and can make allocations of different series to different beneficiaries if it makes sense or if the governing document provides for that. And so I point that out because I think it can make it very easy to, administer trusts that have been set up as well. The other thing I just was kind of thinking about in terms of how are we going to use these things but didn't make it into the presentation was if a beneficiary is wanting money but the trustee doesn't want to give it, the trustee could use another series to be co-owned with the beneficiary and provide money as kind of a loan to that entity from somewhere else within the trust. So I think the options can be kind of limitless in terms of what can be done. And with that, I will turn it over to Chad for some real estate discussion.
Super. Thanks, Jordan. Let's see if I can make this happen effectively. And like Jordan, I will probably repeat a little bit about what he said and maybe a little bit of what Jordan said as well. And my intention here is to explain a little bit what happens when we take a Series LLC that's established in South Dakota and export it outside of the state and some of the issues that we might need to be aware of when that happens. And so really to start at the very basics, I guess, concerning real estate titling, at common law, only individuals could own property. Any entity that owned property owns it as a result of statutory authority. And so as we create a Series LLC in South Dakota and want to move it to Minnesota or North Dakota, for example, do those states authorize Series LLCs to own property and to hold title to property? And if not, can we title them as such? And more importantly, can we leverage them? Banks are looking to that. They want to make sure that it's titled in the right person and right entity for it to be leveraged and to put a valid mortgage against it in that given state. So from the title insurance perspective, as we go through those elements, these are the elements on the screen that we go through. Our series authorized in the state where the property is located, and as has been discussed by both Heath and Jordan, that there's going to be specific legislation required in the particular state where the property is located in order for a series to hold title to property there. Another thing to look at as you're looking at that state's Series LLC laws or looking for their laws possibly would be, is the LLC capable of holding title to real estate? We want to make sure that that's outlined as well. Most states are not terribly specific in their legislation regarding that, but some of them will say something to the effect of all powers of an LLC that's not prohibited by state law. So for example, if a domestic LLC can hold title there, chances are that a South Dakota series that moves there can hold title there. It's a series registered or otherwise validly formed. There are a number of states that require different elements to create an LLC there. South Dakota, as you've heard, requires a certificate of designation, that the operating agreement state that there's a series, as well as keeping separate records. And you'll find that that's fairly common in almost all states. And although not all states require a certificate of designation. So let's take, for example, if you have a South Dakota trust, but you have formed Delaware LLCs underneath there. Delaware has a couple of different forms of LLCs that one of them doesn't require a certificate of designation. If you form that Delaware LLC and buy property in South Dakota, what does that look like? And I don't have an answer for that. That's just a question that you need to consider as you create your trust and create your Series LLCs in another state and want to import it into South Dakota, because South Dakota's laws require a certificate of designation for that series to hold title. Can you rely on Delaware law to hold title for a piece of property in South Dakota? Probably not, but that's something that you need to consider. is the series a separate entity? And this is one of the biggest issues that we have from the lending institutions, is trying to figure out, if I have a series and it certainly is not separately designated, or it's not laid out in the operating agreement that it's a series, is it a separate entity? Can I take the asset that's in that series and either mortgage it, or equally as important and not quite real estate related, can I file a UCC against it? Because if it's not a registered entity according to Article 9 of the UCC, I may not be able to create a valid security interest against that piece of property, whether it be personal property or real estate even. So fortunately, like I said, in South Dakota, we have designated that as a separate entity, and it does work in South Dakota. But if you buy a piece of property in another state, is it a separate entity? And I'll give you a little example of that here in a little bit. Are foreign LLCs authorized in the state where property is located? We want to make sure that you can create a foreign LLC, a foreign series LLC in the state where the property is located, and not just assume you can export South Dakota law into that state. Ironically, I find this a little humorous here. There are several states that authorize foreign LLCs but do not authorize domestic series LLCs. Arizona being one of them, California, Florida being a couple of other ones where they authorize foreign series to operate in their states, but they don't have any provisions for domestic series LLCs. And then, of course, the last question, can a foreign series hold title to real property? Again, statutory language will control that, and usually it's pretty broad. So generally speaking, that's going to, if a domestic series can hold title to real property in that state, a foreign series probably can as well. The other issue, and I don't have it in here either, as I was going through the slides earlier this week after we had submitted them, was sometimes you have lenders that are series LLCs and not just title holders. And that's something to consider. I don't know if any of you folks out there have trusts that make loans or would create an LLC or a series LLC to make loans or represent hard money or private lenders that would make loans under a series structure. But if you form that in South Dakota and make a loan in Minnesota, a state that doesn't specifically authorize series LLCs, and you have to foreclose on that, what happens when you foreclose and take title to that piece of property in Minnesota that doesn't authorize series LLCs? Again, a lot of these questions are unanswered. I don't have an answer for that. It's simply something to consider as you form these series and keep moving forward. So naming requirements. If you form a series in South Dakota, as Keith indicated, you have to use the name of the parent LLC. That isn't always the case in other states, but using the higher standard will never hurt if you have to move to another state that authorizes series LLCs. Using the parent's name is not going to hurt you. But there are several states that have adopted the Uniform Protected Series Act, and Nebraska being one of them, our neighbor to the south. So if you're going to take a South Dakota LLC and move it to Nebraska, you're going to have to include the term Protected Series or PS in the name of the series in order for it to be eligible to be registered in Nebraska. And we may see that as more states adopt the Uniform Protected Series Act. That act came out after we started consideration of our series LLC legislation in South Dakota, and it may be something we have to go back in and amend later. But at this point, we followed the Illinois model, but there is a uniform act out there, Uniform Protected Series Act, that we may need to go back and look at some things at. So if you move into a UPSA state, you might have to rename your series, at least for that state. Maybe a doing business as would work there. So I would also tell you that as you move into these states, as I've indicated there, that sometimes you have to look at the regulatory requirements as well. So Wyoming, for example, to the west of us, the Secretary of State has outlined some naming requirements in its regulations for series, and you might have to use the word series in that state. Some other states you may have to use the word series as well, in addition to the name of the parent. So just be aware of the naming requirements as you move. Those are things to consider, and maybe if you know you're moving into another state, things to consider as you name your series in South Dakota. So as Heath indicated, you can certainly take a current LLC with several assets and divide it up. Probably fairly easy to do in South Dakota. New operating agreement, get a designation of your series with the Secretary of State. May require some deeding back and forth from the master LLC to the series. And if there's any type of mortgage or loans against those property, you'll have to visit with your lender as well to make sure that gets addressed and moved, or either assumed or modified to include the new Series LLC. So I touched base a little bit earlier on the protected series in Delaware. Delaware just passed another law, went into effect in 2019. Delaware was one of the first states to have Series LLCs, and they were fairly nondescript in their statutes. Basically, it said, hey, you can just create one, just name it, and just tell us you're going to have a series in your operating agreement, and that's going to be good enough. Well, then they ran into all the issues that I listed before of whether or not it's a separate entity, whether or not it can hold title to real property, whether or not it can be sued or sue in its own name, things like that. And lenders didn't know how or who to give a loan to or name in the loan documents. And so they went back in and created a protected versus registered series in Delaware. And the registered series would be series that are similar to what they currently had, what they had prior. Just tell us that it's a Series LLC and we'll go with it. And if you want it to be a protected series, now you need to go back in and register those, each individual series with the Secretary of State, much like you do in South Dakota. So just something to be aware of as you move, if you're going to use a Delaware LLC as well. And finally, there aren't a lot of cases out there concerning LLCs. There's 4 of them that I'm aware of. There may be more, but these I found a little bit interesting. Flatten versus Couture is actually a North Dakota case, and it's a good example of language, I think, or a finding where you have a state that doesn't authorize LLCs. In this case, Couture was the managing partner of a Nevada LLC. Nevada allows series, had some property up in North Dakota, in the Bakken oil field. Flatten agreed to buy it. Couture backed out of there and basically said, Flatten sued him and his entity that was registered in North Dakota. And Couture put up the defense that, well, that's not the entity that holds title to the property. My series owns title to that property. You're suing the wrong entity. And the North Dakota Supreme Court said, well, your master series is the only one that's registered here. We would have no other way to know that it's a series. And in dicta, they basically said, we're not even sure that series are allowed in North Dakota because there's no statute allowing them. So it's kind of an interesting case. I found basically, iterating a little bit of the things that I've said here today, that, if there's no statute regarding that, regarding Series LLC in a given state, can they even, hold title or do business there for that matter? Alphonse versus Archbay Holdings is a lending case where, again, they had a lot of confusion as to the proper party that should be foreclosing, and was decided on other grounds, but it's kind of an interesting read. FA versus Las Vegas Development concerns Nevada LLC specifically, but it's really interesting in my opinion, because while it says Series LLCs are legitimate there and a Series LLC can sue and be sued, a Series LLC is not a separate entity in Nevada. So you could sue the master LLC there as opposed to the series, because the series is not a separate entity. I think we have fixed that problem in South Dakota, so we shouldn't have that issue. But again, if you're going to Las Vegas, you might want to make sure that, or Nevada, you might want to make sure that you have make sure that your entity is registered there and is a separate series. And the city of Urbana versus Platinum Group out of Illinois is where we modeled our legislation from. I thought was a nice case because it basically says you can't just tell us that you're a Series LLC. You've actually got to prove it and follow through with naming this series in your operating agreement, having separate records, having a certificate of designation, things like that. You just don't get to claim that it's a Series LLC. So that court there put some teeth into the statutes and might be a good one to follow if something comes up in South Dakota regarding whether or not something is or is not a Series LLC, or who to sue, what's the proper party to sue or not sue. So with that, I guess we move to questions. And I think, Jeff, were you handling questions today? Or Heath, I guess.
I think those are being forwarded to Heath.
Yep.
And there are no questions in the queue at this time.
Okay. Well, thank you, Heath, Jordan, and Chad. If those in attendance do have any additional questions, please contact the State Bar at info@sdbar.net, and they will be directed to the presenters. Once you leave today's webinar, you will receive a survey on the presentation, and we would really appreciate it if you would complete that and provide your feedback. Any closing thoughts, guys?
Jeff, this is Heath. I didn't mention it, but there is an attachment to the presentation that contains some language that I think would work for I guess kind of a streamlined series LLC operating agreement that people could use to incorporate into their agreements. So I just wanted to highlight that's there. It's certainly not fully vetted or in final form or anything, but I think it's a good starting point for kind of the more simple series LLC operating agreement.
And there is one question that come in. So Heath, I did forward that to you just now. And the question is, if you have a number of LLCs that are already formed, what is the best way strategically to do a master LLC? Do you have to refile and rename?
I think you would pick one of the LLCs that you want to be your holding company, and then create your series, and then work on moving assets over into those series. So I think it would take a little bit of effort, but in theory, if the ownership structure of all those entities is currently the same, there wouldn't be any taxable event occurring by pulling assets out of the existing entities to the current members, and then have those members contribute them to the what will become the master LLC. So and once you if it's stuff that doesn't have a title like real estate, once you get that into the master LLC, then it's more of an internal bookkeeping question of what series do you allocate it to, whether you physically move it or title it in the name of the series, is maybe driven more by lenders than which, but that's probably the process I would employ.
All right, thank you, Heath. There are no other questions in the queue. So Jeff, I'll turn it back over to you.
And again, I just want to thank you guys, Heath, Jordan, and Chad. That was a great introduction to the new statute, and I suppose it's like anything else we do every day. Our questions won't really come to us until we sit down to try to do it. So on behalf of the State Bar of South Dakota, thank you. Thank you for presenting, and for everyone who joined us, thank you for joining us, and have a great rest of your day.